Thank you, Mr. Chairman. I appreciate the witnesses being here today. I've been bouncing between meetings and other hearings, and so I apologize in advance if I'm going to ask you something that's been that may seem repetitive to you. Mr. Downing, if I understand correctly, certain proposals for addressing the issues that we're examining today would be to focus less on the location of the data itself and more on the citizenship and physical location of the individual about whom the information is being sought. Does it concern you from a law enforcement perspective about a scenario where a U.S. company doesn't know the citizenship or physical location of the individual and so declines to turn over the evidence? Or I guess related to that, feels that the government hasn't sufficiently established the citizenship and still declines?
That's absolutely a concern of ours. If we have a rule which is based solely on the citizenship of the person, and it doesn't take into account the very common situation where we don't know that person's citizenship, and that blocks us from getting evidence, that's a very serious problem. We often are in a situation where we have, let's say, a hacker or a child sexual exploiter who is hidden from us by the anonymity that's provided by the internet. It can't be that we don't get to access that information simply because we don't know who the person is yet.
Okay. I caught that as I was walking in, someone was asking you about wiretaps. As a former prosecutor, my perspective on wiretaps is they're traditionally thought of as listening into phone calls in real time. The request from the UK here with respect to the U.S.-UK bilateral agreement would not be to do that, correct?
I'm sorry, did you? The rules that we are proposing would be that if there is a targeting of an investigation which is not a U.S. person, if it's a UK person, for example, and they need to get a wiretap for that person, but the only place that the wiretap could be effectuated is in the United States, that it would be part of the agreement that they could use their own wiretap law, their own wiretap order, with their own restrictions, and then the U.S. company would comply with that foreign legal process.
Okay, and so would it also apply in the context of text messaging and other features like that?
Yes, absolutely. It would be for all kinds of communications, not just verbal ones.
Okay. So then let me ask you, Mr. McGinnis, and I appreciate you traveling all the way here, and I represent East Texas, and I've enjoyed listening to your far East Texas accent this morning. But one of the topics that's the subject of debate and ultimately reauthorization here in this country will be tools like 702 of our FISA Amendment Act, that a tool that can result in the incidental collection on U.S. persons. So how does the UK treat incidentally collected communications that involve foreign persons under this?
Let me say, first of all, my family in East Texas, so I hope you're looking after them well, my aunt and uncle and cousins. To be clear, and I think we've said it, but it's worth saying again, the proposed UK-US framework that we're talking about is not about US citizens and not about persons in the United States, so categorically not. When we talk about foreign persons and how they are protected in this, it is US persons who are protected. Other foreign citizens are not. That is because the conspiracies that we look at for almost everything that we look at under serious crime, unless there is a single actor, involve people of multiple nationalities. And that's true if we're looking at, I know, Albanian crime groups trafficking people into the UK. That's true if we're looking at recent conspirators and attackers in the United States, in the United Kingdom, targeting who've carried out attacks. There are multiple nationalities and multiple connections externally. And we covered this a little bit earlier, but it's worth repeating, within this agreement and within the language that has been sent by the administration to the Congress, there is a very clear protection for the rights of US citizens and US persons, and an expectation that Should we inadvertently collect the communications of a US person, that as soon as that is evident, we will desist and we will delete the data, we will minimize the data, so that protections are in place. That is obviously something, the exact detail of how we do that is to be discussed if you agree there should be an agreement, but I am confident we can set a very high standard.
Okay, that would apply, and my time's expired, but so that would apply if, for instance, a UK subject communicates via email with a U.S. person. Those are you're talking about applying those privacy safeguards to the U.S. person.
Indeed,
in that email.
if I write to my cousins.
Yeah. Okay, very good. I appreciate that. Thank you.